Good night, Belizeans at home and abroad. This is the Belizean Affairs Show number 433. 433. My name is Leonard Brackett. I'll be your host and chairman for tonight, as well as your co engineer. Uh, Let me see, we have here. Tonight being Friday, of course, we'll be dealing with some constitutional matters and legal matters, as well as other issues. As we normally do in the beginning of our program, we do a short prayer and then we do a reading from the scriptures. So I'll just bow my head and proceed with the prayer. Divine loving Savior, as we come before thy presence once more, we pray that thou must have mercy upon us, that thou would guide us, strengthen us, protect us, give us wisdom, knowledge, and understanding, endurance, perseverance, and a bit of fortitude, loving Father. Please help that we may present a worthy program tonight to our Belizeans at home and abroad and others. And whatever we say and do tonight may accrue to the benefit and well being. We pray that thou must bless our family members, friends, and loved ones wherever they are. Thou knowest them by name and number. Please let the words of our mouth and the meditation of our hearts be acceptable before thy divine presence, now and always. We pray that thou must bless our Belizeans at home and abroad, as well as bless our country and leaders. We pray that thou must bless the country and leaders and people of this country as well, and, and the rest of humanity. For we ask these mercies in Jesus' name. Amen. Before I do the reading, I'll just ask that you allow me the opportunity to launch the other part of the platform. Let me see. And then after that, I'll go ahead and fill in the rest. Let's see. No. Okay, there we go. All right, so all right, I launched that part, and so I'll just proceed then to do our reading for tonight. And our reading for tonight we will take from, let me see, I was going to Daniel, but I changed my mind. Let's go here in the New Testament and see what we can find. Okay. Let's see. Okay. So I'll read from the New Testament. And I'll read chapter St. John, chapter 5, starting at verse 21. For as the Father raised up the dead and quickeneth them, even so the Son quickeneth whom he will. For the Father judgeth no man, but hath committed all, all judgment unto the Son, that all men should honor the Son, even as they honor the Father. He that honoreth not the Son honoreth not the Father, which hath sent him. And that is the reading for tonight. Our program for tonight will deal with some constitutional matters, as I indicated earlier. And just like to, first of all, go to the particular location where I'm going to retrieve that data. Let's see, this one. Okay, I'm downloading the matter. I don't see anyone else in the background yet, so I'll just proceed. Okay. Emergency powers. Let's see. Let me just turn it sideways so I can. Oops, I need to keep this in, otherwise it's going to make noise. Okay. Okay. So, amendment, let me see. Okay, I'll skip that one. I think we did that one before. Try 55, amendment. Okay. Yeah. For tonight, we're going to deal with the recommendations, some of the recommendations that was made by the PCC Commission, People's Constitutional Commission. And as we all know, the endeavor there was to come up with some thoughts or ideas that the people would want to have taken out of their constitution and or added into their constitution. But the people were not educated substantively enough for them to really understand the significance of what was in the Constitution currently, and therefore be in a position to be able to determine what they want to excise from it or take away from it. But those who started out the undertaking to eviscerate the Constitution had in their pocket an agenda that they wanted to pursue, but they were just recruiting the people to go along so that it appears that it was the people that wanted to pursue this particular agenda. And presumably they will lay the blame on the people. So we have recommendation number 55 that they made, said, amend to remove the Governor General's powers and it went on to say, replace the Governor General's functions in emergency powers with the Prime Minister and the National Assembly. That is to say, they were going to commit sedition as well as treason to go to the Assembly and vote on these recommendations that they wanted to have in the Constitution to replace what was in the Constitution, which is the treason, with what they wanted in order for them to maintain power, as well as grabbing powers that were outside of their reach. That is to say, in our country, in our system of governance, we have three different branches of the government, as is normally stated. And I have recently been stating that while we have enumerated three sections of the government, there is another section of the government that's supposed to change from a three-legged stool to a four-legged chair. And the reason why the people have powers reserved unto them that are delegated and left in reserve for the people to exercise and not for the politicians to exercise or for the government to exercise without the people's consent or for the judiciary to tamper with without the people's acquiescence. That is that there are reserved powers. There's powers given unto the three section of government as is largely stipulated. That is, the judiciary have their own powers authorized to them in the Constitution. You have also the legislative body with powers authorized to them in the Constitution. And then you have the executive authority with powers authorized to them under the Constitution. And like I said earlier, you have powers that are not authorized to any of these three branches of government, which are largely the purview and are reserved powers of the people. And unless the government come to the people with a referendum, which it says in the Constitution, there shall be a referendum in regards to any of these matters that the government wants to tamper with. They have to come to the people as a plebiscite and to have a referendum telling the people what is it that they would like to have the people agree to in terms of modifying or changing their constitution, especially if they're going to touch any of the forbidden third rails in the Constitution, such as the separation of powers doctrine that governs the three branches, or the powers that people are born with, that the government has no authority and rights to tread upon and or to eviscerate or trample on, such as the Section 3 all the way through Section 19 of the present Constitution, which are the powers that are or inalienable rights. The Constitution does not give us those powers. We, the people, demand that those issues be added into our Constitution as an enshrined part of the process to make sure that the government cannot alter them, cannot transgress them, and that only with our acquiescence, the people, the general public, those who are registered to vote, what you call the plebiscite of the country, and through the form, as I stipulated earlier, by via of a referendum, that the government can then get the permission of the people to deal with any of those matters. Otherwise, those powers remain vested in the people. And because they are not enumerated, that doesn't mean that the government can just go ahead then and make laws to enumerate them and or to transgress them or to deal with them however they wish, because it's reserved powers to the people. It's out of the purview of the government. Those powers are out of the purview of the legislator, it's out of the purview of the executive, and they are also out of the purview of the judiciary. But some of our politicians, because they know that a lot of people don't know about these issues or understand these issues, they play fast and loose with the process of legislative practices. They play fast and loose with creating what the Constitution under Section 2 says classify as other laws, which when they are violative to the Constitution are to be considered as null and void. And yet we have our government use the mechanism of governance to implement policies of state that outrightly and deliberately transgress the Constitution. All because they choose to act as scofflaws. They choose to disregard the laws and to bullyrag the process and to have their own way because they have the power of the purse, and they figure nobody's going to challenge them. And even when people challenge them, as in the case of Section 90 violation, they hire all kind of lawyers to come and advocate on their behalf and for them to pressure against the public interests and the public citizens who are having to sue the government for the government to do what the Constitution requires of them to do. Now they're coming with this grand idea of wanting to have you, the people, allow them to change the Constitution in ways that will allow them to self-inoculate from the transgressions and their violations of our lawful system. They want to be able to harness the power of governance at the highest level to the point now where they're proposing in this amendment proposal to write out of the laws of our country the executive powers that are vested, as the Constitution says, in the head of state. And we only have one head of state at a time. So according to them, they're going to write a legislation that will authorize them, apparently. I don't know how come, because the Constitution already said in Section 2 that any law that is violative of the Constitution is to be deemed as null and void. And if you are going to violate the separation of powers doctrines, which many judges in the past had ruled that is impermissible, that is to say, it is not permissible for the government to violate any of those particular laws. Because as Section 2 says, the supreme law of Belize is the Constitution. And if any other law that is written by the legislator is inconsistent with the Constitution, then they got to go back and redo that law until it becomes consistent with the Constitution, because the supreme law of the land is the Constitution. And to the extent of the inconsistencies that they make these laws with, to say that these laws do not abide by the constitutional prescripts, it means then that the law is bogus. It has no legality. It has no merits of lawfulness. It has no constitutional basis or background for it. So if it violates the Constitution, it cannot be a law. It is unlawful from the get-go. Yet these knuckleheads are going to come to you, the public, and try to bamboozle you in saying that they want to transgress the separation of powers doctrine. That is to say, in the separation of powers doctrine, you have the judiciary, you have the legislature, and you have the executive. But they want to violate the authority that is not vested in them. They, as subordinate officers in our constitutional framework, they want to overthrow the system and grab the powers onto themselves. They did not They don't want to go and negotiate with the head of state and see if the head of state would accede or yield to their desire, because they desire to become the head of state themselves. And we have dealt with some of those matters before. I hope that people will recall at least bits and pieces of what we have dealt with and how they were resolved or how they were spoken about, in order for us to move forward and deal with other parts so that they can learn and understand a little bit more before these jackals that come to us with these proposed constitutional amendments and want us to vote on it, or to just let them go ahead and don't give us an opportunity in a referendum to vote, but for them to just go ahead and try to legislate it on their own in the assembly or in the house. What they're trying to do, they're precluded from doing, or they're not supposed to be able to do, especially trying to do it unlawfully, illegally, and unconstitutionally. I'll just read on a little bit here, because then I need to go to the Constitution. And they went on to stipulate that Section 22(1) in the definition of court should be amended to remove the reference to Her Majesty or His Majesty in council. And they are presuming that by removing that particular part of the Constitution, according to them, which is a transgression, it's a seditious act to start with, as I previously stipulated, but it's also a treasonous act, because they're trying to grab power onto themselves, ultimate power onto themselves, for them to be able to use and give us worse governance than they're currently giving us. Does anybody believe that if they get additional powers granted to them, or if they can capture or grab additional powers or vest themselves with those extra powers, that somehow or another they will become better operators or better government? The extra powers that they're trying to put their hands on is, like I said, to inoculate or to immune themselves from being able to be prosecutable for the violations that they already are committing and they're hoping to commit, because they already stated when they were trying to bring that Amendment 13 that they wanted to exculpate government officials for crimes that had been committed before the law was even brought into existence. That's bogus. That's malignancy. You don't make retroactive laws, especially as regards to tampering with your constitution. You only have one constitution at a time. You only have laws that are current until they are changed. And you can't commit a crime under a specific legal framework and then turn around, because you change the constitution, it means then that that unlawful act or that behavior or that illegal act or that contravention of the single existing constitution can be made whole by just you writing a new law and say you exculpate yourself, and everything that happened in the past is then, all right. You're excusing all the crimes that you commit in the past. What are you going to end up doing with the crimes that you commit in the future then? Or for those crimes that are currently being committed? Because if we look at the system that we have in our governance right now, there's a lot of illegality going on, a lot of criminal conduct on the parts of high officials, as well as low officials. So then what's the purpose of having a jail or having a prison? Because if you, the high officials, are committing crime, violating the Constitution and violating other people's basic civil rights or whatever, and you can't be prosecuted and you can't go to jail, then what's the purpose of persecuting anybody else and sending them to jail? Nobody's above the law. But these jackals want to be above the law, and that's the purpose for them trying to talk craziness here about eviscerating the Constitution and create something that is more pliable to their deviousness. What I read just now was one of the recommendations, and that was recommendation number 56. I want to go to the Constitution of Belize and read up a little bit about the context of that particular recommendation that they are making. Let me see quickly. I need to go. Yeah, okay. Okay, so then now I want to go to. Just spare me a second. I'm trying to retrieve the information. I'm trying to find my electronic version of the Constitution of Belize. And as soon as I find it, then I'm just going to go to the section that I want to read. There's so much stuff on this particular device. Okay, I found it. Let me open it up and then I'll go to the particular section that I would like to address. Let me see, that's section 34. Let me see. 19, I need to go to 34. Yep, okay. Okay, so I just need to turn it sideways now so I can. Okay, so we got. I might have to go back a little bit closer. Okay, 34. Okay, so the Constitution of Belize, as I made reference to earlier, under Part 4, referring to the Governor General, establishment of office, it says, there shall be a Governor General of Belize, who shall be a citizen of Belize, appointed by Her Majesty or His Majesty, and the Governor General shall hold office during Her Majesty or His Majesty's pleasure, and who shall be Her Majesty or His Majesty's representative in Belize. That is, that the Governor General of Belize serves at the pleasure of the head of state. It says, during the period when the office of Governor General is vacant, or the holder of the office of Governor General is absent from Belize, or is for any other reason unable to perform the functions of his office, those functions shall be performed by such person as Her Majesty may appoint. And in this case, they're referring to a Deputy Governor General who would operate when the Governor General is indisposed or unavailable. Under Section 32, it goes on to read, a person appointed to hold the office of Governor General shall, that's a command, right? Comma. Before entering upon the duties of the office, that person shall take and subscribe the oath of allegiance and office. That is the oath of allegiance to the Constitution and country and people of Belize, and the oath of office as the Governor General of Belize. Under Section 33, it reads further. Section 33, subsection 1 reads as follows. Whenever the Governor General has occasion to be absent from the seat of government, but not from Belize, or, as in the case of paragraph B, has occasion to be absent from Belize for a period while he or she considers acting in his own deliberate judgment, that is to say, in the own deliberate judgment of the Governor General, the Governor General will be consider that they're going to be absent for a short period of time, or is suffering from an illness which he or she considers acting in his or her own deliberate judgment will be of short duration. He or she, as Governor General, may, acting in accordance with the advice of the Prime Minister, he or she shall appoint any person in Belize to be his deputy during such absence or illness, and in that capacity to perform on his behalf or her behalf such of the functions of the office of Governor General as may be specified in the instrument by which he or she, as Deputy Governor General, is appointed. So, in other words, when the Governor General is indisposed or unavailable, there is allowed for in the Constitution of Belize someone who can act in their absence. But that person can only act in their absence in as much as the detail that the appointment, which is called a writ, that is given by the Governor General for that person to act, and that person just cannot act in all the capacity of the Governor General. They are only authorized to act in a limited way with limited functions for limited purposes. That is to say, matters that should come to the Governor General for her or his signature should not be delayed until the Governor General is not available, only to have the Deputy Governor General then have to go and sign, because the Deputy Governor General is not vested with all the powers that is vested in the Governor General. They are what you call reserve powers that the Governor General does not transfer to the Deputy Governor General. So likewise, there are what you call reserve powers that the head of state have, that the head of state does not transfer those particular reserve powers to the Governor General. And as we said earlier, the Constitution of Belize, we dealt with before, the Constitution of Belize says that the executive powers and authority of Belize is vested in the head of state. And some of those powers are delegated to the Governor General, who then can delegate some of her powers to subordinate officers of hers in order to run the country on a day-to-day basis. And those delegated powers are not all the reserve powers that the Governor General has. Just like how the Governor General is not vested with all the powers, reserve powers that the head of state has, the Governor General cannot vest all of her powers in her subordinate officers. And the subordinate officers that we're talking about are the ones that go to the Governor General for ascension of state governance after they have won the general election. So, if the Prime Minister and the other ministers are subordinate officers to the Governor General, how the devils can they, the Prime Minister or the legislative body, has any powers unto themselves that is beyond that of the Governor General, or beyond that of the head of state, so that they would be able to say, well, in their powers, they can dismiss and get rid of the Governor General and or the head of state. They don't have those powers granted to them. Those powers are not within their purview. They are not assented to them, or even assentable in the first place. Because the Prime Minister can't fire the Governor General. The Prime Minister have no authority to fire the Governor General. Nor does the Prime Minister have any authority to fire the head of state. The Governor General works at the pleasure of the head of state. And the Governor General grants permission to the Prime Minister and the head of departments, the ministers, their portfolio. And the Constitution says that the legislature has no powers to authorize any authority to the Governor General, because that's the opposite. It is the Governor General that authorizes authority to the legislature and assent to legislative endeavors for those legislative endeavors to become legal, lawful, constitutional, and operational. So how can these jokers come here and make the recommendation, as I read earlier, to eviscerate the position of the Governor General and the head of state? With what legal, constitutional authority do they think that they will be able to do that? And let's take, for example, if they were to just go ahead as they are proposing to do now and take that to the legislator, and the legislator decide to vote in whatever numbers, even if they have 100% of them voting in favor of that particular recommendation, which they had here, recommendation number 54 that I read earlier, to get rid of the Governor General and the head of state, who is going to assent or authorize when they go ahead and make an act in the House of Representatives? Who is the person that they are going to go to assent to that act? The very same Governor General. So are you telling me that these people are so smart that they're going to hope that the Governor General will grant them powers that she don't have? But for some reason or another, they could believe that maybe, even if she were to say, well, sign off on their proposal to get rid of the Governor General, that the Governor General has any such reserve powers to do that for them? Even if she wanted to, she does not have those reserve powers. She works for somebody else. She works at the pleasure of the head of state. And she can't fire herself, or you can't fire the head of state, who is her boss. Her boss can fire her. If that boss was to find out that she is playing hanky-panky with the government of the day, committing sedition or attempting to commit sedition against the, well, not only just sedition, high treason, and I would say more than just treason, I would say probably high treason, because they are high officials. To undermine our system of government, to overthrow our system of government in order for them to grab the powers of head of state. Why? Because they want to turn the country into a republic where they will vote for one member of themselves to then inherit that powers of head of state according to them. And who is going to grant them that? I don't know. I can't grant them that. They can't grant themselves that. the Governor General cannot grant them that, because the granting of such privilege is outside of the lawful, legal, and constitutional purview of the Governor General, and they can't do it for themselves. They can't assent to their own laws. They can't assent to their own proposals. Hopefully, they might get some sense and probably figure out how to negotiate with the head of state. But I'm quite sure the head of state have good queens and kings councils to advise them, to advise him. Whereas the Governor General does not have any good legal, lawful, constitutional individuals who are providing her with the best of advice, rather than the skullduggery that they're trying to perpetrate, which is to have her sign onto stuff that she's totally oblivious of or know nothing about, or that they're not trying to inform her about. They're just trying to get her to put her seal on it. And under that, guys, they're going to pretend to say, well, the Governor General signed it, so it must be legal. There are many laws that the Governor General have signed that was finally ruled as unconstitutional. I'm not talking anything new. I'm talking about the history of the country, how the rules and regulations and how the laws operate or are supposed to operate as compared to these scoff laws that they're perpetrating on us. Anyhow, I'll just read a little bit more of this. I'll go to section 2. Section 2 of the same section that I just read just now, which is section, let me double check here again. 36. Yeah. Okay. So it's section 2 of section 36. Let me double check. No, not section 33. Section 33. Let me read it though, and move on. Subsection 2 says, the power and authority of the Governor General shall not be abridged. What does it say? Shall not be abridged. So I don't understand and see how these guys who are lawyers in cabinet and lawyers in the Senate and all the other private lawyers that they can hire, both locally in Belize as well as foreigners. The last time they're gone and I hired Mr. Menendez, a foreign lawyer. They also hired, before Mr. Menendez, they hired Mr. Josewicz. Okay? They have the treasury. They can hire lawyers all over the world to advise them adequately as to these matters if they really don't understand it. But they don't want to pretend like even they understand it or not. They just want to go through the mechanics, bamboozle the process, and pretend that, they have done things legally, lawfully, and constitutionally. And on that basis, if they were to have doing things legally, lawfully, and constitutionally, then the idea is that they'll be doing what's right. And therefore, they'll be justified to say, well, we did everything the correct way, and this is how the thing turned out. Disregarding the fact that it would be different than what it is currently. You only have one constitution at a time. And there are ways how you go about changing your existing constitution. But if they don't want to follow the rules, the regulations, the guidelines, the policies, the prescripts of the Constitution, then how the devils do they expect to legalize what they're trying to get done? They don't care if they do it legally or illegally. They just want to have it done because at the end of the process, in their mind, it appears that once it's done, it's done. And those are the things of revolutions in countries. For example, it says here, anyhow, The powers and authority of the Governor General shall not be abridged, altered, or in any way affected by the appointment of a deputy under this section. So they can't take the Deputy Governor General, Mr. Stuart Leslie, who is also the Secretary of Cabinet, and have him go into the Governor General's office as the Deputy Governor General and use the Governor General's seal and signature process to sign off or assent to any bogus underhanded activity on their part, because he does not have any such powers to be able to overrule the power and authority of the Governor General herself. Nor can he dispatch the Governor General on their on Cabinet's behalf, because he's Secretary to Cabinet. But that's how these jackals think, and that's what they're hoping to have done. It's not the first time that they have attempted to do this kind of shenanigans. But I'll go on. I'll go on to read another little portion here. It says, okay, I want to skip those. I want to go to section 34, which speaks about the exercise of Governor General's functions. In other words, the purview. What's the purview of the Governor General as compared to the purview of these knuckleheads? These wannabe. Section 34 of the Constitution of Belize under subsection 1 reads as follows. In the exercise of his or her functions, the Governor General shall act in accordance with the advice of the Cabinet or minister, or a minister acting under the general authority of the Cabinet, except in cases where he or she is required by this Constitution or any other law to act in accordance with the advice of or after consultation with any person or authority other than the Cabinet, or in his or her own deliberate judgment. That is to say, even after consulting with any other entity or individual, the Governor General still has the right to make whatever decision they're going to make finally within his or her own deliberate judgment, irrespective of any consultation or advice from anybody else. Subsection 2 of section 34 reads as follows. Any reference in this Constitution to the functions of the Governor General shall be construed as a reference to his power or her power and duties in the exercise of the executive authority of Belize, which is vested in Her Majesty and delegated, some of it delegated to the Governor Generals, and to any other powers and duties conferred or imposed on him or her as Governor General by or under the Constitution of or any other law. Subsection 3 reads as follows. Whereby this Constitution, the Governor General is required to perform any function after consultation with any person or authority, he or she shall not be obliged to exercise that function in accordance with the advice of that person or authority. Why? Because they have the powers or reserve powers unto themselves to make their final decision based on their own deliberate judgment. Subsection 4 reads as follows. Whereby this Constitution, the Governor General is required to perform any functions in accordance with the advice of or after consultation with any person or authority. The question whether the Governor General has so exercised that function shall not be inquired into by any court of law. I don't know if I need to read that over again, but I hope people get what that is implying, okay? I'll go to section 35. It says, the Prime Minister shall keep the Governor General fully informed concerning the general conduct of the government of Belize, and shall furnish the Governor General with such information as he or she, as Governor General, may request with respect to any particular matter relating to the governance of Belize. I'll now go to part 5 of the Constitution. I don't see any of my colleagues in the background, so it's a one-man show for tonight, I presume, and in the interest of timing and public interest, I'll pursue the presentation of the program as I have it stipulated. So, under part 5 of the Constitution, it speaks about the executive and the executive power of Belize. Section 36 of the Constitution of Belize, subsection 1 reads as follows. The executive authority of Belize is vested in Her Majesty, or in the absence or demise of Her Majesty, in His Majesty. So I'm going to read that again for emphasis. Section 36, subsection 1 reads, the executive authority of Belize is vested in Her Majesty or His Majesty as head of state. Subsection 2 of the same section 36 goes on to read, subject to the provisions of this Constitution, the executive authority of Belize may be exercised on behalf of Her Majesty or His Majesty by the Governor General, either directly or through officers subordinate to him or her as Governor General. Remember, I alluded to that a little earlier. Under subsection 3, it goes on to say, nothing in this section shall prevent the National Assembly from conferring functions on, there's a word missing out here, on other persons or authorities. And then we'll say, other than the Governor General himself or herself. That is to say, the legislative body has no power to authorize or to grant authority or power to the Governor General, who is a superior officer to those in the legislature. So it is the Governor General that assents to powers of the legislative process in terms of granting legitimacy or executive authority to the legislations that the legislative body brings about. And if the legislative body brings about a legislation or a law that is contrary to the Constitution or violates or is violative of the Constitution, then it is for the court to deem such law or legislation as being unconstitutional. The legislator can make a million different laws, but they must be constitutional. In other words, those laws must come within the prescripts and within the walls of the Constitution. Anything outside of the Constitution is null and void, as is stated in section 2 of the Constitution. The second section of the Constitution, section 2 says, this Constitution is the executive, is the supreme law of Belize. And if any other law, such as those that the legislator made, is inconsistent with the Constitution, then to the extent of its inconsistencies, that other law is deemable or should be deemed as null and void because it's violative of the Constitution. And you only have one Constitution at a time. You can't have a Constitution and then you make a law that is violative of the Constitution and pretend that that law is lawful. It is not. Anything that violates the Constitution is unlawful, illegal, and unconstitutional. As I keep repeating, you only have one valid Constitution at a time. Anyhow, I proceed. Nothing in this section shall prevent the National Assembly from conferring. Nothing in this session shall prevent, in this section, which is section 36, and we are reading subsection 3 right now. Nothing in this section shall prevent the National Assembly from conferring functions on persons or authorities other than the Governor General. So they have no authority over the Governor General because they are subordinate officers and they report or deal with the Governor General as a superior officer to themselves. Under Section 37 of the Constitution of Belize, it goes on to say, subsection 1 reads as follows: there shall be a Prime Minister of Belize who shall be appointed by the Governor General. Why? Again, because the Prime Minister is a subordinate officer to the Governor General. We read that before, right? And we keep going around in circles with these things to see how they connect, to see where the powers and the authorities reside. So the Prime Minister cannot appoint a Governor General. It is the Governor General that appoints the Prime Minister. Of course, there are different things that has to go as protocols in how you get to that point where the appointment is made. But the way these jackals would like to have the public believe it is that it's just the opposite. The Governor General is the figurehead, and the Prime Minister is the commanding general, in the running of the affairs of the country. And that commanding general as Prime Minister can exercise executive powers to the point of eviscerating and or transgressing the constitutional order of things, whereby the legislative body bends to the Prime Minister, and also that the judiciary should also bend to the Prime Minister, because then, according to their proposals here in these amendments that I was reading earlier, one of those proposals stipulates that the Prime Minister would become then the new head of state. But there's a process to get there. But they don't want to follow the process. They want whatever comes out of their head to become the law of the day. And that's how things are supposed to work. Only scofflaws and scoundrels operate in that kind of way. I read section 37 as follows, subsection 1. There shall be a Prime Minister of Belize who shall be appointed by the Governor General. And under subsection 2 of that same section 37, it says, whenever the Governor General has occasion to appoint a Prime Minister, he or she as Governor General shall appoint a member of the House of Representatives who is the leader of the political party which commands the support of the majority of the members of that House. That is to say, that House, or that the term of the House, that particular term. Because the House remains, but the terms, they keep changing according to the elections. So whoever gets the majority of the parliamentarians on their side, that's the person that has the privilege to go to the Governor General to be assented to as Prime Minister, and the members of his cabinet, according to or who he wishes to fill those positions. But it is to the Governor General that they go to, the same person that they try to let the people believe is a figurehead, without which they cannot assume any powers of governance. They have to go to the Governor General to get sworn in, to be assented, and for them to sign their documents and swear their oaths of office and their allegiance to the Constitution and the country and people, without which they don't have no powers to enter into running the country or managing the country. There has to be that transference of power. And it is their superior officer that is given the privilege by the head of state to act on behalf of the head of state to transfer some of those powers to them. But they want to assume the position and posture that, well, because they are sent to run the country, it means then that they have ultimate power and authority to vanquish the very same person to whom they go and get the authority from. And no way in our Constitution does it allow for that. That's a violation of the structure of our government, the basic structure, and the separation of powers. The structure of our governance is such that the Prime Minister, the ministers are subordinate officer to the Prime Minister. The Prime Minister is a subordinate officer to the Governor General. The Governor General is a subordinate officer to the head of state. What part of that it takes them? How long is it that they're trying to play this shenanigan for them to recognize, realize, and or accept or deal with? They don't have to go to, I mean, even a kid at elementary school should be able to understand that basic premise or recognize that basic premise. And I presume someone, who studies law and has gone to law school is competent and should be capable enough to understand that basic premise. And yet these jackals or scofflaws refuse to abide by the rules. They refuse to play by the rules. They want to violate the laws and do all manner of evil, sit in cabinet and conspire against the best interests of the country and the structure of the country and its governance. Let me proceed. Anyway, I'll just read that subsection 2 to its completion. Whenever the Governor General has an occasion to appoint a Prime Minister, he shall appoint a member of the House of Representatives who is the leader of the political party which commands the support of the majority of the members of that House. And if no political party has an overall majority, he or she, as Governor General, shall appoint a member of that House who appears to him or her as Governor General as likely to command the support of the majority of the members of that House. A second paragraph in that same subsection reads as follows: provided that no person shall be appointed as a Prime Minister who has previously held the office of the Prime Minister for 3 parliamentary terms, either consecutively or in aggregate. And for this purpose, the expression parliamentary term shall mean the period commencing on the date of the first sitting of the National Assembly after a general election and expiring at the date of the next ensuing dissolution of the National Assembly. Subsection 3 reads as follows: if occasion arise for making an appointment to the office of Prime Minister, while the National Assembly is dissolved, then, comma, notwithstanding the provisions of subsection 2 above of this section, a person who was a member of the House of Representatives immediately before the dissolution may be appointed as Prime Minister. As we read earlier, a Prime Minister cannot serve more than 3 terms. So if in the case where Mr. Barrow had served 3 terms, he was termed out. And if his party had won again, he would not be able to be a Prime Minister. Another member of his party would then have to assume the position of Prime Minister. Same thing for Mr. Belizean or any other, as in the case of any other political party. We previously read that a Prime Minister can only serve 3 terms. And in the case now that we're talking about, where it says if the House is dissolved and there's a space of time, there's a space between the election, a person who was a member of the House of Representatives immediately before the dissolution may be appointed as Prime Minister. Subsection 4 goes on to say, the Governor General shall remove the Prime Minister from office if a resolution of no confidence in the government is passed by the House of Representatives and the Prime Minister does not within 7 days either resign from his office or advise the Governor General to dissolve the National Assembly. It is to be understood as well, contextually, this is a technical point I'm bringing across. It is to be understood contextually that if a Prime Minister had served 3 terms and his party goes on to win a 4th term, that Prime Minister then cannot be a Prime Minister in the 4th term because he's restricted to serve only 3 terms constitutionally. But that would not stop him from being able to run for his seat, win his seat, and just serve as in some other capacity in the government other than in the capacity as Prime Minister. Because then he would have already be barred from being able to serve as Prime Minister. But he can then serve as a minister or in some other cabinet position, or he may be able to serve as a senator, or he can just serve as a backbencher. But the Constitution precludes him from being able to serve a 4th term, whether in aggregate or consecutively. I'll read on to, let me see what's my timing here right now. Oh, I have enough time. I'll read on to subsection 5, which is also critical as a part of understanding the powers and authority within the separation of powers doctrine of the Governor General, Ms. Salam, who is the current Governor General, or any other Governor General, whether it's a he or she in any other case. In this instance, we're talking about Ms. Salam. But subsection 5 of this section reads as follows. The office of Prime Minister shall also become vacant, as in the case of paragraph A, which says, if the holder of the office ceases to be a member of the House of Representatives, otherwise than by reason of the dissolution of the National Assembly. So in other words, the office of the Prime Minister shall become vacant. That is that the Prime Minister should give up or should not be in the position of being a prime minister if the holder of the office ceases to be a member of the House of Representatives. That is, if he retires from the House of Representatives, then he cannot continue to be the prime minister. Or for whatever reason that he, you know, okay, I'll skip that part and I'll go on to paragraph B. If by virtue of section 59(3) of this Constitution, he is required to cease to perform his function as a member of the House, or if he is informed by the Governor General that the Governor General is in accordance with subsection 2 that we just read before, or subsection 3 also that we just read before too, of this section, about to reappoint him as prime minister, or to appoint another person as prime minister. That is to say, the Governor General is not just a figurehead, and the prime minister is the boss or the head of the executive. If the prime minister's superior officer as the Governor General, for whatever justifiable reason within the bounds of the Constitution, including these that are stipulated here, finds it necessary to appoint another prime minister, then she has that reserved power to do so. And there's nothing that the prime minister can do about it. It hasn't happened yet in our country, because so far everything has worked out and there has never been any need for any of these particular technical issues to be aired out and or to be acted on. But the reserve power is there. The Governor General appoints, and she can withdraw those appointments as part of her reserve powers. So if the Prime Minister comes to the Governor General, let's say next month when they go to the House and want to pass this Constitution evisceration or modification, the Governor General doesn't have to sign that particular revised Constitution or assent to it for it to become legal, lawful, and give it any legal basis. She can refuse to assent it, or she can just, send it back down. Why? Because of the transgressions in there, the onerousness of that particular document, to say that they are making that document with the idea of eviscerating the Governor General's position and the position of the Governor General's boss. Unless she, as Governor General, is acquiescing to seditious actions or behaviors by the legislator and or by the other officers of the government that are subordinate to her, unless she is willing to lend her support to pretend that, well, if she says yes, they can go ahead and do what they are attempting to do, it means then that she is also participating and lending ear and comfort to seditious behavior, therefore putting herself in a position of acting in a seditious manner herself and acting in a treasonous way, for that matter of fact, because she knows that the powers to eviscerate her position or the position of her boss does not lie with these jackals. But that's what these jackals are pretending to do. Go through a motion and pretend that by any sense of the imagination, completing that motion would vest them with the legal authority that is vested in the head of state. That's baloney. And I would say maybe baloney and cheese without bread. So it's not a complete sandwich. I'm just trying to be funny and lighten up the these are weighty matters, right? And I will not have more than about 5 more minutes to go, because we will not do a full 90 minutes today. We'll probably do about 80 minutes at the most. I don't have enough time. The last few programs that we've been doing, we have been going over the time period, and right now we run out of time basically. So I would not be able to do a full 90 minutes program tonight. So I'll just keep checking on right now and just deliver as much of this program as I can, and defer the rest of it for some other occasion, maybe next Friday or some other time. Um, I still have a little piece here that I wanted to get through though, so let me just go to that. Uh, in the exercise of the powers conferred on him or her by this section, the Governor General shall act in his or her own deliberate judgment in regards to the matters stated above. And then also, as regards to Section 38 of the Constitution of Belize, it says, the Governor General shall, acting in accordance with the advice of the Prime Minister, designate a minister as Deputy Prime Minister, to whom the Prime Minister may, from time to time, deputy such of his functions as may be specified. And I'll close off the constitutional reading for tonight. And I'd just like to go back to the, what precipitated all those readings in terms of what I was talking about relating to the obnoxious recommendation number 55 from the PCC Act, which is seditious and treasonous and in bad faith. Recommendation number 55 says to amend in such a way as to remove the Governor General's power. Now, I don't know how they want to remove the power of the person that gives them power, but good luck. Replace the Governor General's functions in emergency powers with that of the Prime Minister. That is to say, they want to allow the Prime Minister to inherit or to observe or somehow acquire the powers and authority vested in the Governor General for it to be vested in the Prime Minister. And I guess they are hoping that just by going to the National Assembly and making moves in the National Assembly and writing a bogus law, an unconstitutional law, a law that is inconsistent with our Constitution, which is intending to boldfacedly abrogate and eviscerate parts of our Constitution as regards to powers that they don't have and they cannot act on or give credence or legitimacy to, because they are powers that comes under the purview of the separation of powers doctrine. They don't have that power given to them from the people. And even if the people want to give them that power, if they come to the people with a referendum and the people say, yes, we'll give you that power to go ahead and do that, the people are not sovereign citizens yet. Belize is not a republic. It's not a dictatorship. It's a parliamentary democracy. And it has a head of state who is accountable for the issues that they are trying to resolve on their own. And it's like they are trying to slap out of the head of state's hand the head of state sandwich. They're trying to act like a bully to go and grab something out of somebody's hand that they want. But they will make a law that is inconsistent with the Constitution of Belize and pretend that that inconsistent law, which is already deemed null and void from its inception, somehow grants them the power, authority, or vests in them the power and authority of the head of state. So I like to say, like I said before, good luck. But don't bring that kind of shenanigan to me and expect that I won't sit on the wayside and pretend that, nothing is going on. The least I could do is speak to it, point out the errors of their way, the omissions, the deliberate gangsterism that they're trying to perpetrate on the people, only to pursue the issue of having a bigger and better hustle, because that's all they're interested in, hustling. They have done nothing to help the society to move forward. All they're doing is impoverishing the society, making laws to oppress and suppress the society, and to squeeze more money as much as possible out of the people, even at a 68% poverty rate. They're onerous and devious-minded people. They act like goons. Have they been acting? Recently, though, they realize that they're under so much pressure. They're putting out a whole lot of speech and statements about how good they want to do for the country and a whole lot of stuff. They should have been doing that. They shouldn't come out now and start make a new promise all over. Get about doing the business of the country and help the people move the country forward. And as I said, I will not be able to go to the 90 minutes, so therefore I'll wrap this up and hopefully be able to take up the rest of it on another occasion, as I said. Again, my name is Leonard Brackett. I was your chairman and host for tonight. And this was the Belizean Affairs Show number 433, 433. And all I could say is thank you for your time spared in listening to whatever I had to offer. I hope that your valuable time would have allowed you the opportunity to grasp or be exposed to something that might be of interest to you, might help you to understand the dire straits that our country is in. And if and when these jackals decide to bring this matter to our attention, because it doesn't appear that they want to publish this information with enough time so people can read through this material and learn what they need to know before they are being asked whether or not they like it, because that's how these jackals operate, Anyhow, thank you very much, Belizeans at home and abroad, and others who listen to our program when it's live, and to those who will listen to it after they get home from work or maybe on the weekends. Thanks for your attention, and I hope that you derive some positive public benefit from our programming. Good night and goodbye. See you next week.